So it's really unfortunate that I felt the need that I had to send this email directly to the Brown County Attorney's Office. As you saw in my previous video, it seems like a lot of no answers, haven't gotten to it yet. We're super busy. Please learn to be patient, despite the fact that this report was made over a month ago and whatnot. And then I had a phone call today that said, obviously from the advocate, that it hadn't still been reviewed yet. She didn't know when it was going to be reviewed. She didn't know what the timeline was. That, obviously there was a process that they follow after it's entered, but she didn't know how and when he decides to look at things. And then also, of course, they're busy, other cases, and he still needs to keep on top of his daily tasks. So she doesn't have any idea as to tell me when I can even expect to hear that it's been reviewed. And I, of course, explained to her, well, I'm just going to keep calling. It is my job as my child's advocate to bark up your tree, to make sure that you don't forget us again, to make sure that you don't lose all of this stuff again, that you don't just sweep us aside and be like, oh, that's okay, because that's what you guys have been doing. And then I hear the same phrase that I've been told so many countless times that I swear if I had $1 for every time I heard it, I would be rich. I would not have to worry about a lot of things. That statement is, but you have the order for protection, don't you? Yes, I do. Oh, well, that keeps you safe. No, it doesn't. First of all, an order for protection is not justice. An order for protection does not address or hold accountable a man who sexually assaults their children, who physically assaults their children, who threatens to kill their children, who rapes another woman in front of their children. That's not what an order for protection is for. So I'm sorry that I'm not accepting that answer. And to address the, oh, well, that makes you safe. No, it doesn't. Oh, but it's enactable in all 50 states. Yes, it is enactable. Not everybody likes to follow the rules, as was demonstrated in my divorce when he directly violated this order for protection to gerrymander and seek contact from the kids to install the process. Not to mention there's this stupid modification in there that says he can keep doing it. So I'm sorry, to quote my attorney from Minnesota, go back and tell them you're not safe. Go back and tell them your children are not safe because of this little sentence. This is why you're not safe. So here I am, Brown County. Here I am, Chuck Hansen. Not only am I telling you my children are not safe from this person, I'm telling you need to pay attention, because for the last 4 to 5 years it hasn't happened. So I'm going to share with all of you the email that I decided I needed to send him. So forgive me, I obviously will be looking down at my computer screen because I don't have it memorized. It says, "Good afternoon. My name is Samantha. I am the mother of," I'm just going to call him C for here, "the woman who has been calling you regularly for the past week or so, seeking updates on my son's case and advocating for his justice in order to keep it in the light of your office so that this one doesn't magically disappear or wind up at the bottom of a long-lost, forgotten drawer for a year again. Your mission statement states, the Brown County Attorney's Office is to provide for the public safety by aggressively, yet fairly, prosecuting those individuals who violate the law, and to steadfastly protect the rights of crime victims and advocate the cause of justice, and to provide the highest quality legal representation to county government to benefit all of the taxpayers in Brown County." It's a lovely mission statement. I would like you to be aware that it is broken. This is not the representation I have seen at all in the past 4, almost 5 years. Our case has been steadfastly and constantly mishandled, manhandled, lost, goofed up, etc., and no one wants to take accountability for it. No one is willing to stand by this mission statement in its truest and simplest context. I have been told countless times that my order for protection should be good enough, that everyone is busy, that my children's trauma doesn't matter, that in essence, the sexual assaults, physical assaults, and threats they received at the hands of their father do not matter. And worse yet, that it's okay. I'm here to stand up and tell you and anyone else in New Ulm that this is unacceptable. Your jobs are not being done. You are not holding people accountable. You are not protecting your community. You are perpetuating the cycle of child abuse and domestic violence and sending the message to my children, namely C in this instance, that his voice, his story, his suffering, and his courage mean absolutely nothing. I implore you to please stop looking the other way. Stand behind your mission statement and stop sweeping us under the rug. Stop silencing us. Stop silencing my child. He deserves justice. At 10 years old, his voice, his recollection of events, combined with the domestic violence knowledge is your smoking gun. Give it a chance to fire. This child has more gumption than most men, certainly more than his perpetrator will ever have, and he's been begging for New Ulm to hear him. He desperately wanted to testify and talk to Judge Doherty at our order for protection hearing. My ex-husband, his abuser, was allowed to silence him and his sister. The responses I have received from your office in regards to my son's case, I give the case number obviously, have been at both ends of the spectrum. On the very first day I called, I was given wonderful lip service about how you pride your office on not letting people fall through the cracks, and due diligence is done to look at cases, thoroughly investigate them, etc. I was told this was not a repeat of our past experiences, but simply that the office has been busy with other trials and that they were not making excuses. It kept getting referred to as the all-crim sex one. I was told that it would be decided on by that Friday, November 22nd, and that she would personally call me either way to let me know. I received no such call, so I placed it myself. Imagine my surprise when my small balloon of hope that your office has changed and was taking us seriously because of that call quickly dashed when the same person was rude and short with me, telling me it had just been entered into the computer that day, and surely the crime victim advocate must have already called me to tell me, which had not happened yet, and that I needed to be more patient because you were short-staffed. I was then told that Monday or Tuesday at the latest now. Late Monday afternoon, I reached back out. I was told by Bernie that that morning nothing had come of it yet, and she was waiting to hear back. So I waited a bit longer, and I called again myself. I was giving the same rude response, but shorter. Tuesday afternoon, today, I reached back out again. Initially to Bernie, where I got voicemail and told her that I was checking in again, as well as to leave a secondary number should the snowstorm we are anticipating hit and knocks my cell service out as I live in a rural community. I thought it would be best to reach out to your office and also give them this number on the slim off chance that the previous week's word of calling me no matter what was honored. The person who answered and spoke to me was initially was very cordial. She said she believed I had been talking to Charlene. I confirmed, and she said to let her transfer me back to her. After a brief hold, she then, came on the line and said, "Never mind, I'm going to pass you to Bernie." And suddenly I was back at Bernie's voicemail. Bernie did reach back out to me a bit later and let me know that it still hasn't been reviewed yet. To be patient, that there's a process, that she has no idea how he picks and chooses what he's working on and when, again, plus still trying to stay on top of his other daily tasks. I explained that I was simply making sure we weren't past aside and forgotten again, because my child deserves justice. My child wants to know why no one from New Ulm will listen to him or let him talk. Again, I was told, but you have the order for protection, so you're safe from him. I'm sorry, but an order for protection that he conceded to where none of us were allowed to testify is not justice. That is not holding him accountable for sexually assaulting my child, raping another woman in his presence, threatening to kill him, etc. It also is not a safety guarantee for my children, as he is constantly taking me to family court because no one in the judicial system has bothered to hold him accountable or tell him to knock it off. This is but a brief description as to why I am calling your office at the end of each day to see where my son's case stands, to remind you that we are still here and that my child is still waiting for justice. Since New Ulm police don't do a very good job to actually investigating, taking statements, following through, or documenting statements, I am attaching in this email statements I gave to Tom Borgen for my order for protection trial. It is the condensed version of many, many abuse disclosures and how those disclosures were made by my children. Please find some time to read them. They speak volumes, but if nothing else, to protect the children living in your community from this man. Because my guess is that if he had no qualms about doing this to his own flesh and blood, he won't care if it's a child he has no connection or relation to. I am also attaching some photos. The one of my son's ear is what he talks about in his report as well. I also have text messages from my ex where he refers to the day I called police when he physically assaulted our oldest daughter, a report that was not only messed up, but lost for 3 months. And the best that could be done after was to re-educate the officer. Trust me when I say that I understand your office may very well be busy. I do not dispute that. What I am saying is that is no excuse for injustice and poor quality work. Thank you for your time, attention, and understanding to this very important matter. I then attached the photos. I then attached the 45-page statement of everything that has ever been disclosed, on the dates they were disclosed, and the context in which they were disclosed. Will he actually sit down and read this email or read the attachments? No clue. I have no faith in that. I'm not going to sugarcoat it and give myself false hope and say, oh yeah, he's totally going to read this and pay attention. To be honest, I don't think that at all. But I would be doing my son a great disservice if I didn't reach out and try. Because this is what surviving looks like. This is what advocating for the broken system to be fixed looks like. This is what it looks like to not only be a domestic violence survivor, but to be the mother of a child trauma survivor who hasn't received justice, who hasn't been acknowledged by the system, who keeps getting passed along because people think they have other things to do, other more important things, or because his father belongs to a family that not only has money, but has some pretty strong connections to the community, and how dare we try to unveil that charade. So, again, New Ulm, can you hear me now? Are you even listening?